Hello, and welcome to Season 1, Episode 2 of ARBinBRIEF, a practical video guide on hand-picked arbitration issues. I'm Dara Sahab, and I am a member of the ARBinBRIEF team. ARBinBRIEF offers a quick resource to consult on issues that arise in international arbitration, while showcasing talented arbitrators in an interview format. Over the course of 10 episodes in the first season, we will move through the life cycle of an arbitration. Following our first episode on arbitral appointments, which you can watch soon on ARBinBRIEF's YouTube channel, today we go through what to do once you're appointed. To help us do that, I'm honored to introduce our arbitrators. Chiann Bao is an arbitrator at Arbitration Chambers based in Hong Kong. She has served as co-arbitrator and chair on many international tribunals and under the administration of international institutions, including SIAC, AAA, ICC, and HKIAC. Chiann has also served as counsel and in arbitrations and as the Secretary General of the HKIAC. She's admitted to practice law in New York and Hong Kong. And Fatima Balfaqeeh is the Managing Director of RKAH Legal Consultancy in Abu Dhabi, the UAE, serving as counsel, independent arbitrator, and mediator. Fatima focuses on construction-related matters, including governance, enforcement in contracts, and procurement for government entities. We'd like to also thank our partner organizations, Delos, Mundi, and ARbitralWomen for their invaluable support, and ArbitralWomen for their ongoing promotion. Delos Dispute Resolution is an independent arbitral institution established in 2014, and during the interview, we'll have a question around the Delos rules. Mundi provides arbitration research tools for lawyers, including a directory of more than 5,000 lawyers, profiles with arbitrator analytics, such as Ms. Bao and Ms. Balfaqeeh. Their pledge establishes concrete and actionable steps to increase the number of women appointed as arbitrators with the goal of reaching full parity. For those who are joining us live, the 15-minute interview will be followed by a 15-minute Q&A. Please send any questions you have through the Q&A function. Over to you, Chiann and Fatima.
Thank you very much, Dara. It is a pleasure to be here today with you and with Fatima. I love the format, I have to say, of this, this seminar or this webinar that we have today. And so I'm very excited to have this conversation with Fatima about what you do when you first get your first appointment. Now, as with, I think, the normal structure of this seminar, I get to ask the questions and then Fatima gets to answer them. And then we'll have a brief chat maybe, and before we move on to the next question. Now, Fatima, the first question is, now the arbitrator is appointed, what is the first thing that she or he needs to do?
First of all, thank you very much, Chiann, and thank you to Dara and ARBinBRIEF as well for hosting us today. And I have to echo what Chiann have said, such an interesting format for this webinar. So regarding the first question, one of the very first things that you should do once you are appointed as an arbitrator is to look at the case file. Now, the case file is a very good starting point for any arbitrator because it provides them with the overall picture of the case before them. This case file. And you have a duty to make sure that you get it on time. Usually in a lot of jurisdictions, the start of the duration or the time limit given to you to render an award starts from the transfer of the case file. In addition, after you receive this file, you need to look at the arbitration clause or agreement because you need to make sure that you have a jurisdiction over this arbitration or arbitral proceeding. In addition, you need to look at the procedural rules that applies to this arbitration, depending on, again, if it's an institutional arbitration, then you need to look at the institute. But if you're an ad hoc arbitration, then you need to ensure that you will set out a very clear set of rules to manage those arbitrations.
Yeah, those are some really great tips, Fatima. I think it's really important that you look at the file first and really know what you're getting yourself into before you even send that first email to the parties or your co-arbitrators, so that you have a general sense as to the parameters of your case that you're dealing with. So the second question is, what are the key differences between being appointed as a sole arbitrator, a co-arbitrator, or a presiding arbitrator when preparing for a case?
Okay, so in all cases, you are appointed as an arbitrator, right? So you will have the duty to make sure that you're going to render an award. But what is your role in rendering the award? This is what differs when it comes to thinking about sole arbitrator, co-arbitrator, or presiding arbitrator. Let me start with the top of the hierarchy, let's say, with the presiding arbitrator. The presiding arbitrator is usually the one who kind of steers the ship and leads the team of co-arbitrators. They set the tone and pace of the arbitration. They issue all the main communications to the parties, and usually they're the one who lead the effort in issuing the award as well. So and also they will be like the determining voice within this tribunal of 3 or rarely 5, but it does happen. This is the role of the presiding arbitrator, I would say. And again, most of the rules, they stipulate exact procedure on how to appoint this presiding arbitrator. And usually it comes by nomination by the 2 co-arbitrators, or if the 2 co-arbitrators cannot agree this presiding arbitrator, then they are nominated through the center. And if it's an ad hoc case, then it's nominated through sometimes the courts even. When you're a sole arbitrator, then you are responsible. Again, it really overlaps with the role of a presiding arbitrator, but there you are really the main point and the sole point of responsibility of running the arbitration from start to finish. So you're responsible for all the communication. There is nobody to deliberate with. And finally, moving to the situation involving a co-arbitrator. Of course, a co-arbitrator, that is not a license for you to sit back and kick back and leave the whole job to your presiding arbitrator. You also have a duty to review the case file, give your opinion, deliberate, sound any trigger points that you think that were missed in order to make sure and ensure that this arbitral procedure will render at the end a very enforceable award.
Yeah, no, this is certainly helpful to distinguish between the 3 roles. And of course, not all roles are technically created equal, although I think the role is generally in principle to be the adjudicator and to ensure that the parties receive a fair and efficient process, of course. I do think that it can be sometimes lonely as a sole arbitrator for the reasons that you've kind of described when you're running the case on your own and you have you don't have wingmen to kind of check, or wingwomen to ensure that, you know, things are going in the direction that they should, and that you don't have a check on the system. On the other hand, when you're a presiding arbitrator, sometimes if you have co-arbitrators who may be a bit slow with their email responses, etc., you find that there may be some lag because you need to build consensus with the tribunal. And of course, the tribunal itself has different dynamics that you have to be conscious of. So there are pluses and minuses, I think, to each of the roles. But certainly I think having the opportunity to sit in different roles gives you a better perspective of what the other side looks like. For example, if you're a co-arbitrator, then you know how it feels more to kind of sit in that role versus being a presiding arbitrator and then having to manage all of it. So it's nice to have the variety. So the next question is, what documents need to be prepared before the first CMC?
In general, the following documents need to be issued and signed by the parties to be produced by the CMC. I think if you don't have a procedure set, then you have to issue a procedural rule in order, especially at the case of an ad hoc case, you really need to make sure that you have a set of rules that have been agreed by both parties before you start and kick off your procedure, basically, because the CMC is basically the start of the procedural aspect of your
Yeah, that's helpful to kind of give a sneak preview as to what needs to be prepared. And I think different arbitrators have different approaches in terms of how they prepare for the first CMC. I have seen some arbitrators who like to ask a set of initial questions to the parties so that they can help themselves build a procedural framework in preparation for the CMC. I myself, in that initial email that goes to the parties, I'm oftentimes already kind of thinking about, you know, getting a CMC agenda, as you say, and giving the parties an opportunity to kind of comment on any particular procedural aspects that they are looking for. Oftentimes, I will also indicate that, you know, within a number of days and prior to the CMC, I will circulate a procedural order number 1 template of aspects and features that I like to use and that fit with the case, and then give the parties an opportunity to comment on it. And sometimes that helps with the efficiency of that actual case management conference once it's had. The other aspect, of course, is the procedural timetable, which ultimately depends on, you know, the parties and kind of whether they want, what kind of briefing they want. And the timing will oftentimes work out as to, based on working backwards, based on the hearing dates that are fixed. And obviously hearing dates can be quite tricky sometimes when you're dealing with busy arbitrators, busy counsel. So sometimes you spend more time dealing with fixing that hearing date and then everything else kind of falls in place. But it is important to get those initial dates locked down as early as possible. So the next question is, in case of an ad hoc arbitration, are there additional measures that need to be taken into account?
Yeah, in case of an ad hoc arbitration, you don't have really the safety net when it comes to an institution to guide the parties, to guide the arbitrators. So you really need to take care and agree with the parties beforehand and make a very solid terms of reference or a procedural agreement or any agreement beforehand. So you will avoid the deadlock situations where one of the parties is trying to do a guerrilla tactic and try to delay or stall any of the procedure later on. So when it comes to an ad hoc case, I really think that the arbitrator should really be careful about the procedure they're using, the soft laws they're using, and they really need to choose a soft law that they're very familiar with, so they will avoid any deadlock situations for sure.
Yeah, I think a couple of additional points that I might mention include, when you're dealing with an ad hoc arbitration, as you know, UNCITRAL rules will give you some sort of a framework. So parties can obviously agree to UNCITRAL rules. And sometimes an ad hoc arbitration is even, can be an UNCITRAL rules arbitration administered by an institution where the institution does provide very basic support, like fund holding or other aspects. So there is a variation within the definition of ad hoc arbitration as well. The other aspect I think I would add to your comment in relation to what's needed is a terms of appointment. And certainly as an arbitrator, it's useful to fix that terms of appointment with the parties so that everybody is on the same page as to what is to be expected when as arbitrator being appointed by the parties. And institutional arbitrations will have that kind of either in their guidance notes or practice notes, or even in the context of those issues will be dealt with in the body of the rules or the institutional practice. Right, so we have one last question, and it's a Delos question. So the Delos question is, how do you understand Article 7.2 of the Delos rules in light of the varying approaches to these matters found in the arbitration rules?
I think that the cornerstones of arbitration in general is the agreement of the parties. And we will see that a lot of other rules kind of imply that the parties can agree their own procedural and evidentiary matters. But I believe that the tribunal should have the discretion to agree those proposed evidentiary and procedural aspects that were proposed by the parties, or amend to it in order to have a robust, efficient, and effective procedure. But given that the Delos have given such an explicit power, then I think it really aids in the times that we have a deadlock and the parties do not agree.
Yes, and if I just might add one last point on these Delos 7.2, which indicates that the tribunal shall have the power to determine all procedural and evidentiary matters. As you say, this is generally known to be inherent powers, but it's helpful to have it expressly set out. The second part of this provision indicates the parties are encouraged to agree on joint proposals on procedural and evidentiary matters for consideration by the tribunal. And this really kind of puts the onus again on the parties to also jointly agree as much as they can as to the framework, which I think is a helpful provision to support the tribunal's work when trying to get the parties to agree to a procedural framework.
Great.
Dara, I see you're back on screen. Back to you.
I first want to thank you, Chiann and Fatima, for this incredibly insightful discussion. To everyone, to see future ARBinBRIEF videos, please follow us on LinkedIn and subscribe to our YouTube channel, and we'd love to hear your comments and feedback. And you can register for our next episode on our website, www.arbinbrief.com.